Welcome back. As we mentioned at the start of the show, despite all the reaction to the Trump indictment news, we still don't know what the charges actually are. Sources say we can expect about 30 charges, but what does that mean? The exact details won't be revealed until the indictment is unsealed. That is now likely to happen Tuesday. The DA could on his own unseal it right now if he wanted to. But we do expect it Tuesday, at least, the day that Trump will be arraigned. And, of course, this case is not the only one that faces the former president. So with us to dive deeper into all of this is NBC News senior legal correspondent Laura Jarrett and Daniel Horwitz, a former Manhattan assistant district attorney and now a defense attorney specializing in fraud cases. So, Laura, let's start with the Manhattan case here as we go deeper. But I do want to ask you where you think things stand with the other two investigations in Washington and Atlanta. But let's start with this one. What's the why would the prosecutor wait to unseal the indictment until after the arraignment? Is this just prosecutor discretion?
Yeah, it's totally in Alvin Bragg's hands. He could unseal it today if he wanted to, but sources have told us that they're not going to do that, and it's totally regular for them to unseal it when Trump faces his arraignment on Tuesday, at least. That's when we expect that to happen. I think there had been some question about whether they would do it sooner than that, especially given the heightened public interest and obviously the media attention around this case. We've been able to report about at least a rough number of counts, and so you can imagine if Bragg wants to be in the driver's seat sort of dictating how all of this rolls out, you could see them trying to get it out earlier, but no indication that it's coming out today, and we should expect it to come at least Tuesday, Chuck.
Laura, how, given that, I don't want to say there's been some misdirection by the DA's office with the media, but who knows what it is. Look, we all deal with sources. You think you've got it, you're not sure, all this stuff. How much do you think we don't know here? I mean, we've got questions about Alan Weisselberg, for instance. Do we think he appeared before the grand jury or not? That's something we just don't seem to know.
We don't know because remember he could have, he could have gone in a different way, considering that he's actually in custody right now. But we don't have any reporting about that he was in front of the grand jury. But it's supposed to be a secret process, and perhaps he went in on a day that we just didn't notice. We should note, however, that he switched lawyers not too long ago, which is notable. But as far as we understand it, his current lawyers are still being paid by the Trump organization, so perhaps that doesn't inure to Alvin Bragg's benefit.
And we know about David Pecker, but there hasn't been any, I mean, let me ask you this. Anybody involved with the Karen McDougal side of this story, did they get brought before this grand jury or just David Pecker?
As far as we understand it, we know that David Pecker was there at least twice, and that New York Times has reported that Keith Davidson, who at one point represented Karen McDougal, appeared before the grand jury. We didn't catch her on camera going in there. It doesn't mean to say that other people who know about how that payment was structured. But Pecker is probably the best possible witness on this, considering AMI, his previous employer and the place that he used to work, is the one that actually paid the money to Karen McDougal. Right.
Let me bring Daniel Horwitz into this conversation. Daniel, you've worked in this office, so help us here. If we do math, individual checks and the counts, should we start to assume that the number of counts and the number of checks maybe times 2 or 3 here?
You got it, Chuck. That's exactly what they're doing. And, this particular crime, falsifying business records, which I charged many times when I was a prosecutor and have defended as a defense lawyer, it's an art and not a science. So let me explain what I mean in terms of charging. You're absolutely right. Under the law, each individual false business record can be a separate count or a separate crime. So you got it right. Each check, each invoice, each entry in the general ledger. Add them up, and if it comes up to 30, that's what you got. Now, when I say it's an art versus not a science, and maybe this is a little bit too much inside baseball, but my own view was I've seen prosecutors charge 200 of these kinds of crimes where you've got many, many business records. And my view always was pick your top 5 and charge those. But I can understand in this particular case why each individual false record, the prosecutors would want to charge that as a separate crime. You don't want to leave anything to doubt, but I think you're spot on about what's going on here in terms of the number of counts.
If this is indeed where they're going, this is something Cy Vance could have done during his tenure. Why do you think it didn't happen?
I think there are a variety of reasons. I mean, I think, first of all, during Cy's tenure, the Southern District was already looking at this case, and Cy had begun his investigation into the the valuation issues with the former president's assets, and so they were pretty down the road on that. And I think they were committed to that, and obviously not committed. They went very far down the road. They went to the Supreme Court in that case. So I think there are a variety of reasons that relate to resources, wanting to stay out of the Southern District's hair as they were doing the Cohen case. And I think it's as simple as that. And that as soon as, I will say that, and I've said this before, I think that, when Alvin took office, when D.A. Bragg took office, he and his team took a very careful, deliberative look on their own about what they thought about the strengths and weaknesses of an overvaluation case, and clearly made a decision that that's a case that needed more work, and that there was this case, and frankly, it was right for them to start digging into at that point. And also because, remember, during most of Cy's time, Donald Trump was still the president. Right. So, you've got the Department of Justice.
He only had about a 1 year. He really only had a 1 year window there where Trump was a private citizen. Let me ask you to react to something Lanny Davis said to me. I said, do you think this is an airtight case? And he didn't. Do you agree with him? And do you, Alvin Bragg's first job is to convince a judge that a crime was committed here, correct?
Yeah, absolutely. Look, this is going to be a triable case, no matter what you think in terms of the politics. You've got to prove that the president not only made these records or had people make the records, but that he knew these records were false and that he did it with the intention, as Lanny said, for a political motivation. But as Lanny also said, it would seem, you've got levels of evidence. You've got Cohen, you've got Pecker, you've got witnesses that the media have reported that include Hope Hicks, Kellyanne Conway. You've got records, and so you've got you've got what you need to get a conviction.
So you think a judge will let this go to trial? You don't think this gets tossed?
I don't think this is going to get tossed. I think that they've got good arguments on the statute of limitations. I don't think that the fact that the theory is new and untested. I mean, I've said this before. A long time ago, insider trading was only a civil case. And so when the SEC was founded in 1933, for about 40 or 50, maybe 60 years, 50 years, you've got insider trading handled civil case. Nobody goes to jail. Bob Morgenthau becomes the Southern District U.S. Attorney, and suddenly, out of the blue, insider trading is now a crime. And as we all know, every day in every federal prosecutor's jurisdiction across the country, insider trading is a garden variety crime. So I think the fact that it's untested, that doesn't trouble me.
Fair enough. Laura, let me ask you as best you can what the Manhattan folks seem to telegraph, at least within a wide range of a couple weeks, how close they were. Do you get that same sense out of Fulton County? And look, the special counsel's an opaque process, so I understand that. But what's your sense of where we are timing-wise on Fulton County in particular, and then also Jack Smith?
So on Fulton County, we understand it to be sometime this spring is our best sort of estimation. Of course, Fani Willis had said it would be imminent. That has not come to pass, at least in the media's version of what imminent means. It may work in prosecutors' version of what imminent means, but that one still seems like it has a little bit of work to go. As for the special counsel, that's a bit of a black box when it comes to what Jack Smith is working on and what the timeline is. But I shall point out he's going after getting the testimony of the former vice president of the United States, which I, by all accounts, have reported out would be done at sort of the end game. That's not your opening salvo to go after Pence's testimony. And if, in fact, Pence does not appeal that case and he actually testifies in front of that grand jury, you might be able to see this case wrap up sooner rather than later. Well,
it was all designed to try to get this done sooner rather. There was supposed to be it was supposed to be expedited, whatever that means, to the wheels of justice. Laura Jarrett, our legal correspondent, Daniel Horwitz, the former Manhattan Assistant District Attorney. Thank you both.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.